manager of the president has been singled out by governance experts as one of the key factors that stand in the way of using law enforcement and prosecution as a credible tool in the fight against corruption. It is against this background that this government proposes to establish by an Act of Parliament the Office of the Special Prosecutor to effectively investigate and expeditiously prosecute specific cases of corruption involving influential public figures and accomplices. The development and passage of a bill to provide the legal framework for the establishment of the Office of the Special Prosecutor, vested with full authority and control over the initiation and conduct of proceedings of corruption cases involving political office holders and high-ranking government officials, devoid of political interference or micromanagement, is a top legislative priority of government. It is our belief that the establishment of the Office of the Special Prosecutor, though not a complete or total remedy for the menace of corruption facing our country, will be a major step towards strengthening the anti-corruption regime in this country, and thereby substantially reduce the canker, if not eliminate it. As proposed in the draft bill, the Office of the Special Prosecutor will have the mandate to investigate and prosecute cases of alleged corruption under the Public Procurement Act 203, Act 663, and other corruption-related offenses implicating public officers, political office holders, and their accomplices in the private sector, as well as trace and recover the proceeds of corruption. We believe that the establishment of a dedicated anti-corruption office vested with investigative, prosecutorial, and asset recovery authority will result in an improved execution of our anti-corruption efforts, rather than a continued reliance on multi-purpose or mixed mandate agencies. The objective of this stakeholders workshop is to seek your valued inputs and recommendations on the first draft of the Office of the Special Prosecutor Bill, as developed by my office. We are hopeful that your inputs and recommendations will inform and shape the development of the draft bill prior to its finalization and submission to Cabinet for its approval before it is laid before Parliament. Once the bill is laid in Parliament, there would be the usual opportunity for the public and civil society to comment on the bill and contribute to its further development before it is passed into law. As stakeholders in the fight against corruption, it is our collective civic duty and responsibility to contribute our diverse expertise and perspective toward the development of a sound and effective legal framework to strengthen the anti-corruption regime in the country. The fight against corruption is therefore not the sole prerogative nor the responsibility of any one individual or institution. Rather, it requires the collective effort of all and sundry. My office, therefore, welcomes frank, honest views and criticisms on the bill with a view to improve the draft before you. Before I resume my seat, I would like to commend the organizers of this workshop and the various donors, including STAC, DFID, the Embassy of the Republic of China, the Office of the President, who, in honoring their various pledges, have provided my office with valued assistance to bring this workshop to fruition. May I also commend you, the participants, for the show of support through your positive response to our invitation to this workshop. I wish you all fruitful deliberations in the coming 2 days, and I thank you for your audience.
Thank you, Honorable Attorney General. So I think for me, I picked two
Still live on News Desk. My name is Daniel Dazi. We just brought you back from the Moving Pig Hotel, where the Attorney General Gloria Ekufu was addressing a forum on the draft bill for the office of the Special Prosecutor, one of the major promises of this government during the electioneering period and immediately after. A lot of questions have been asked about that. We'll be bringing you the analysis on the statement she made when she was addressing the forum. And now, still ahead in the bulletin, we'll be telling you why the Africa Center for Energy Policy, ACEP, is calling for investigations into the sale of 5 million substandard petroleum products onto the Guinean market. We'll also hear from them and the Bulk Oil Storage and Transportation Company Limited bust. Also, the Industrial and Commercial Workers Union, ICU, is protesting the mode of appointment of the new head of the National Labour Commission. We'll hear from the ICU and what their issues are. Of course, all of this will be coming up in the next 1 hour. Let's go straight to our first story. And the Industrial and Commercial Workers Union, as I said, is protesting the mode of appointment of the new head of the National Labour Commission. According to the General Secretary, Solomon Kote, the letter informing them of the appointment of the new head of the commission did not indicate that the appointment was made by the president. He says the right processes must be followed. The protest is, however, not supported by all on the Labour front. General Secretary of the Federation of Labour, Abraham Kumsin, sees nothing wrong at all with the process of appointment. He believes they should rather be focusing on what the government is doing to create jobs. Solomon Kote is sticking with his position. Now, he has been saying that apart from everything, they expected that the letter coming to them must have borne the signature of the president. But we've now been joined by Mr. Solomon Kote himself. Let's go to the phone lines and hear from him. Good morning, Mr. Kote.
Good morning, sir.
So in the first place, as you know it, what should be the process of appointment of the head of the Labour Commission?
You know, the Labour Commission have got two sets of workers. We've got the commissioners and the chairman one side, and then the workforce, starting from the chief executive, who is the executive secretary on the other hand. The commissioners and the chairman is appointed by the tripartite, government, labor, and employers. Now, when you come to the other side, it is the sole responsibility of the Public Service Commission. And indeed, ever since the inception of the commission, all executive secretaries have been appointed by the Public Service Commission. In this particular instance, the position is not vacant. There is somebody who is occupying the position of executive secretary, and then an appointment has been made to that. This is where the ICU concern actually.
Mr. Kote.
Hello.
Right, you were mentioning that there is someone occupying the position. Are you referring to Lawyer Dia?
No, I'm referring to Lawyer Bawadia.
Lawyer Bawadia, right. Go ahead, sir.
Okay. So once somebody is opposed and then you appoint somebody else to go and take over, once a position has not been terminated, then we ask you what is going on. Then again, if the appointment is not coming from the Public Service Commission, but now it's coming from the president, then we expect it to see that the president is evoking or using his executive power, who will have to indicate that the president has appointed you or nominated you, blah, blah, blah. Nothing like that is in that letter. That is before us.
So who is this new person, Mr. Kote, sorry to butt in here, but who is this new person who is being appointed by this letter?
Well, when we try to check, it's a former KD MP and a former deputy minister and was with him. I'm not too clear about the name, whether that's someone or something, but maybe I can easily check and then get back to you.
So your qualms is the fact that this appointment was not made by the head of the Public Services Commission?
Exactly. Number one, because we think consistency, and if we have to make structures to work, this is a clear example of it.
So at the moment, since you have these qualms with it, have you spoken with the leadership of the Public Services Commission?
You know, this thing happened just on Friday. As I speak to you now, I'm in Saturday working at some European setting factory. So I'll be back in Accra, God willing, tomorrow, and then I'll take a message from there.
But who signed this letter you received?
It It's signed by the Asante Media as one rapporteur.
I'm sorry, that was not so clear. You said who signed it?
Asante Media too.
Nana Asante Bedieto, the executive secretary of the president.
Yes.
And in your interactions with him, did he mention how come the normal procedure was not used?
You know, I have not gotten to him yet. I have not gotten to him yet. I'm telling you, I should finish my job that we are doing today and get to a ground. I need this, or else when they go, I'll be the follow-up.
But just, is it not a bit premature to come out to express these misgivings about the mode of appointments when you've done no consultation about why this mode was used this time around?
Well, you see, what took place was that some journalists appeared with a letter in their hand, and I expressed IGU's concern. You know, your media somehow and has encouraged this dimension. So those who have listened to me carefully, I kept saying that we need to do further checks on what is for the public. Once the letter is in the public domain, you can stop people from discussing it.
Okay, please hold on the line for me, sir. We've been joined on the other line by the General Secretary of the Federation of Labour, Abraham Kumsin. Thanks for your time, sir. Now, Mr. Kote on the other line is expressing misgivings that this time the letter appointing this new head of the Labour Commission is coming from the Executive Secretary of the President and not the Executive Secretary of the Public Services Commission. Do you share in his views?
I think I've spoken with my colleague this morning on one of the radio stations. And I think this matter, I think we've dealt with it already. So, but I wouldn't want this argument among, labor leaders to continue on this particular
yeah,
issue.
but if you could please state your views, sir, so we could have that clarity for our viewers who are watching us, please.
But he has different opinion about it. I mean, and I think it is normal for these disagreements and things to go on. But I think that the appointing authority, if you look at the appointment letter of Bawadwe himself, it wasn't the Public Service Commission head who signed it. Perhaps they facilitated or they were involved somehow. And I know that it was the chairman of the Labour Commission who recommended the Executive Secretary, that is Bawadwe, to the President for his appointment. And so the appointment is not of Bawadwe himself. Didn't come from the Public Service Commission. It was the presidency that signed the appointment letter of.
Is it not a matter of meddling of the presidency? This is supposed to come from the Public Services Commission. I mean, these are the views of Mr. Solomon Kote.
No, there are some positions that we as Labour people, we have the role to play when it comes to appointing people to the Commission itself. The Commission itself, the chairman, the members to the Commission, Labour is involved in it. But when it comes to, permanent, positions like the Executive Secretary and other staff, we don't come in. But we can raise issues, but we cannot challenge the appointment. Itself. And as he's saying, he's yet to do some, investigation as to how, the appointment was made. But I think that if the Executive Secretary of the President has signed, I don't think that. But is a lawyer. He's a seasoned lawyer. He's a renowned lawyer, and I think that if he knows that what he was going to do, is not lawful, he wouldn't have signed it. And I think that he signed it for and on behalf of the president. And I'm very
But the
sure
question here is that it's not the president himself. I mean, educate me here, but it's not the president himself who is supposed to make that appointment, is it?
No, but Baodua, find out from Baodua who signed his appointment. Baodua, I have information about how he was appointed, the recommendations and all that. You see, at a point last year, EFL raised issues about the vacuum that had been created as a result of the absence of the executive secretary. And they made Dr. Benes Welbeck to act for over 3 years. He was in the acting position. Meanwhile, the Public Service Commission guidelines and policies don't allow any officer in the public service to act for more than 1 year, 12 months. It doesn't allow that. Meanwhile, this lady acted for 3 years plus. So the Federation of Labor raised issues, with the minister, and we were saying that why can't you confirm if the person is competent? Because their policy or their guidelines say that if the person who has acted in that capacity is found to be, performing well, he should be confirmed, or he might immediately be removed from that position. This didn't happen for the 3 years. They were still assessing the person's performance, and we think that it was not proper because the Labour Commission, the institution which is mandated by law to adjudicate on unfair labor practices. So if they themselves tolerate or entertain this kind of unfairness.
Right, that's what I'm good. Mr. Kumsin, please hold the line briefly for us. Let me go to the other line and speak with Mr. Solomon Kote. Now, Mr. Kote.
Hello.
Right, thank you for holding the line for us. It seems like there are some divergent views on the Labour front. We have Mr. Kumsin saying the president is a lawyer. In fact, the executive secretary is also a lawyer, and so we must trust his decision. You are a bit skeptical about it. Is there a bit of an impasse forming, and why these divergent views from Labour?
Well, if you look at my concern, I'm only indicating that the appointing authority is the Public Service Commission. They have done that previously. And Bawakia, I know, he attended interview amidst others, and he had appointment letter from the Public Service Commission. That is my view. I keep saying that one, the Public Service Commission appointed Bawakia with a letter, which of course we cited it, all right, by the head of the Public Service Commission. If government want to make a change, first thing, terminate Bawakia and then bring somebody else, and I should be fine. This is where we are. But not when somebody who has been appointed by appropriate authority, and then another authority also comes and say, I'm bringing somebody else without terminating the existing authority, the existing officer. This is where we have our problem. And then we also looked at how the letter was actually written. These are the concerns about
now about the form of or the mode of appointment. How does that mode of appointment affect the performance or the outputs of the appointee?
We all know that in the Public Service Commission will have to place an active test. People will apply, and then they will attend it. And then whatever shortlisting or whoever becomes successful is appointed to the office. And this happens to all civil servants. And we thought the National Labour Commission, being a public service, body, could not also be different from what has actually happened. But what we are saying is that, well, you are in your office, move out, let somebody come. But once you are there, you bring another person. That is where we think the presidency, maybe didn't look at it well. Or if now that the termination letter is going to come forward here, then we look at it on that.
Right. So, Mr. Kote, finally, so what is your specific request regarding this issue?
Well, we are raising this concern that one, the appointing authority has now changed to the presidency, or the presidency in exercising its executive powers could also appoint without really cause to know that is the position vacant or somebody is still occupying. Because already there's a lot of confusion at the Labour Commission. Okay, the confusion there, those of us who are stakeholders also that in getting the Nana tools elected is also sufficient to represent the decision of the president. Fine, these are the concerns of us.
So you will accept that the new head was appointed by the president and not the executive secretary of the Public Services Commission?
We would prefer it should be the Public Service Commission, because in this country we have been clamoring that we should allow structures to work. So if the existing structure for all civil servants come from the Civil Service Commission, then why this time now we know what we are doing?
Now, if your demand is not met, what's next for you?
Well, as Labour in matters of this, we will leave it there, because through your medium, all Ghanaians have listened, and then they can judge how we want to run this country from today.
Right, thank you very much, Mr. Kote, for your time this morning. Let me just finish up with Mr. Abraham Kumsin of the Federation of Labour. Mr. Kumsin, thank you for your patience holding the line for such a long time. Now, it seems like Mr. Kote is raising some issues here, that there's a current head of the Labour Commission now. He has not been fired, and now a new appointment has been made. The mode of appointments of this person is not exactly clear, and so clarity must be sought. It seems like he's raising some issues, no?
So I think my colleague was talking about the Public Service Commission. They are the appointing authority, but I don't think that Baudua's letter of appointment was signed by the head of the Public Service. I don't think so. I know that his appointment was signed by the president, or the letter came from the presidency, and that he was even on 9 months probation. That's what I know. The recommendation for his appointment was not made by the Public Service Commission. It was made by the chairman of the commission.
The chairman of the Labour Commission?
Yes.
Is this the right thing to do according to the law?
But that has been the practice as far as some of us are concerned. Labour's, role that they play has to do with the appointment of the commission members, but not the staff. The executive secretary is the staff. And by the arrangement, we've come to understand that the appointing authority is the president. And so if they will change the law, then they have to change it for the Public Service Commission to appoint. But I know very well that the last appointment that was made, which brought Bawodia to office, was done by the president. And so if the presidency, and as I said, he was appointed either in May or something, and he was used to serve for 9 months probation. So it could be that even his performance over the period has not been satisfactory. So if your appointment is revoked, in the course of your probationary period, I don't think, if the man himself has an issue, he should go to court.
But the argument of Mr. Kote is that this appointment has not been revoked, no matter what his performance is.
Look, it's like we have been representing employees who are victimized at the commission, and sometimes in court. If the victim himself, if he is a unionized senior officer, he should use the union, the union apparatus to seek redress, or he goes to court. He's a lawyer. It's not for the union, it's not for some of us to fight his cause. He can file a motion or whatever at court and challenge the process or the procedure for getting him out of the place. If he doesn't go, the invisible forces will come there.
Right. Thank you very much, Mr. Abraham Kumsin, for your time this morning. Thank you as well, Mr. Solomon Kote. Now, Mr. Kumsin is the General Secretary of the Federation of Labour. You're still live on Joy News Desk. My name is Daniel Daze. Let's take you back to the Moving Pig Hotel, where the event, the Special Stakeholder Consultation Forum on the Office of the Special Prosecutor, is ongoing. Let's take you there.
Here, I suggest that one of the matters that you would need to look at are where the responsibilities of, say, a YOCO stop, the CID stop, and where the responsibilities of the new office start. You will understand straight away that a plethora of investigation agencies can lead to real difficulty. That you would not, for example, have the evidence or the intelligence gathered and coordinated in one office. So I suggest that when this bill goes to Parliament, or if it becomes law, or when it becomes law, there really has to be a very clear definition of how this office relates to the other agencies that are already in existence. So, just to give you an example, and I've mentioned the Serious Fraud Office only because it's an office I know about. You can imagine the arrangements we have in the UK with police forces and various other agencies charged with investigating and prosecuting fraud. What is the relationship there? Well, what happens is this. By a statement of principle agreed between all law enforcement agencies, it takes on cases of particular gravity. And it is agreed by enforcement agencies that serious cases are handed over to the Serious Fraud Office, and they in turn decide whether they are going to take them on. Now, I think you need, with respect, to think precisely what is going to be the remit of this office. Is it going to take all the cases that you might describe as corruption cases from all over the country? And how would that be managed? I suggest, in all probability, you would say, well, we cannot do it in that way. So you must, in my submission, consider within the Act how you are going to define the remit of this office so that everybody in the office knows and everybody in the other agencies know. I suggest you may find rather than a fraud office that this office would deal with the most serious cases of corruption, which perhaps you might find would be referred from other agencies, but they also would be serious offences investigated and considered simply by this office. So, the law must be clear. Anyone who looks at the law of Ghana and looks to find where the criminal law is can go to an old Act of Parliament and picking through, some are felonies, some are misdemeanors. In respect of some offences, public officials can effectively buy their way out of it by paying the money stolen, as it's generally charged, with interest. I wonder whether or not you in Ghana shouldn't look again at aspects of your criminal code to see if it can be set out much more clearly in a way which is much more publicly accessible and which sets out a much clearer message, both to officials and more widely to the public. I accept that there is a disadvantage in a lot of new law, in that, on the whole, criminal charges cannot be prosecuted retrospectively. But I suggest there's an additional advantage of reviewing, not immediately, perhaps not necessarily within this Act, that would be too great a burden at this stage. But there is some real mileage, I suggest to you, in making the message that this office is not simply about prosecuting corruption that's taken place, but this is a blueprint for how corruption is going to be dealt with in the future. And I give you an example of this, if I may. Hong Kong. Hong Kong in the early 70s had a hugely serious problem of corruption, particularly in the police and the public services. And so it was that they determined that they would bring in an independent commission, which included an independent prosecutorial authority, and they would also review some of the criminal code to see if it was fit for purpose. And their objective was this: the criminal law is not working. And one of the difficulties about any bribery or corruption case is that there are usually no witnesses. And therefore it is very difficult to investigate, and it's very difficult to prove. So it was that the Hong Kong government decided to bring in some obvious improvements to their law. We'll just look at one or two, if we may, in the next slide. Now, you see, this is how they set it out. Section 3, any prescribed officer who solicits or accepts any advantage shall be guilty of an offence. Prescribed officer, state employee. Absolutely clear, isn't it? Section 4, it is an offence for a public servant to solicit or accept any advantage offered as an inducement or reward in connection with the performance of his official duties. Section 5, it is an offence for a public servant to solicit or accept an advantage for providing assistance for another person to secure contracts from that public body. And Section 8, it is an offence for a person to offer an advantage to a public servant while having dealings with the office department of that public servant. So, right, essential point here is that there would be real benefit in taking an initiative like this forward, to have a review of the anti-corruption legislation, to demonstrate with clarity what is caught within the law. I suggest also you might consider making felonies of these crimes. These are the sort of steps which the public would expect. And these are steps, I suggest, which authorities looking to make a real change to corruption law ought to consider. Another, perhaps additional allied improvement that you might consider is whether or not you might not need some altogether new offences. You generally have offences that mirror these offences already, but you do not have them, for example, in the Prevention of Bribery Ordinance, which is a clear document that everyone can see. So let's just look at the next slide, please. Now, as I say, in Hong Kong, corruption was endemic. Police officers were taking backhanders, and everybody knew it was going on. But you could never prove it. You could never prove a bribe being handed over. So they brought in this. any person who A, maintains a standard of living above that which is commensurate with his present or past official emoluments, or B, is in control of pecuniary advances or profit disproportionate to his present or past official emoluments, shall... Are you laughing because you think this would be a good law for Ghana? Unless he gives a satisfactory explanation, I stress, to the court, not to a policeman, to a court, as to how he was able to maintain such a standard of living or how such pecuniary resources or property came under his control, he is guilty of an offence. Now, you know, I said a little while ago that I think you ought to consider a law which is going to have a preventative input. Imagine public officials knowing that you had a law like that. There are actually subsidiary sections to this Act dealing with monies held by family, spouse. In other words, the duty on a person under investigation was clear. This actually was also taken up in Singapore, not perhaps the most liberal regime in the world, but a regime that decided corruption was endemic and there had to be tough steps. So let's see what they did in Singapore.
Imagine public officials having to explain how they got the money to buy houses and cars. That's the idea that is being suggested as the stakeholders forum to discuss the office of the special prosecutor, or better still, the bill that will set up the office of the special prosecutor.